You're on Radio 97. It's time to talk law on this Thursday morning. Our resident lawyer, Despina Priala, of boutique law firm Priala Legal in Runaway Bay, brings her textbooks with her every Thursday. She offers her legal expertise by providing some general advice on the latest of hot topics. She has experience that spans more than 25 years in the area of property and commercial law. She also does the wills too, prepares them as part of estate planning and litigation. With us yet again. Hi, Despina.
Good morning, Wayne. Good morning, Brooke.
Good morning, Wayno. Good morning, Justina. So this morning we're kicking off with a very hot topic. I know we say that every single segment, but this one is juicy. So get ready. Despina, this one is about how to get yourself out of a building contract. And this has come across your table, your desk, just recently with some clients of yours. So can you tell us why you want to talk about this morning?
I would love to talk about it. And the reason why is that I know that there are so many people out there that have signed build contracts to build their dream home. And it's very difficult to get out of a build contract. That's just in principle. So when someone comes to you and says, can I get out of a build contract? Well, it always depends. And it's very difficult to get out and terminate and end a build contract. So this case here, we actually did it and we got our clients out of a build contract. And I want to talk about this real life story. You know, people love to hear these real life examples. And this is something that I have done recently. And we were able to successfully end the contract, get my clients out of this build contract. And it was a bit of a horror story for them. So let's talk about what happened. So let's set the scene. And I do want to say initially, when we talk about build contracts, unfortunately, it's a bit technical. So what I want to try and do is tell the story today and try not to be too technical because we don't want to lose the listeners a little bit. And it's not really a sort of, you know, putting it out there that the listeners won't understand. But with build contracts, there's just a lot involved. So we want to just take the time and explain it really simply because this might very well be you in this situation at the moment. So let's set the scene. So pretty much this time last year, let's say February 2022, these clients of mine signed an off-the-plan contract for land. So we know what off-the-plan is. We signed a contract. It was for a block of land. So they were in for the long haul, like I've talked before on the show. Off-the-plan means you don't own it. You're buying it from a developer and you're sitting around and waiting for the land to be completed by the developer. And this one had an 18-month sunset date. So they knew that from the beginning. Now, within 1 month of signing the off-the-plan contract, because you've got to be under contract first to, you know, own, to buy a block of land or already own it. But in this case, they didn't own it. So within 1 month, they then signed their build contract early upfront, okay? And we didn't act for them at all in the early part. They came to us recently. So they then signed their build contract with a national, very well-known builder who will remain nameless for the purposes of today. And naturally. And what they did is that they signed their build contract. Now, it all seems very innocent. Great. I've got my land under contract, but I haven't settled yet. And I've got a build contract in place to build my dream home. And we, you know, agree on all the plans and the costings. And probably the buyer thinks I've got my build price locked in as well. And I've got the land price locked in. Happy days. The problem with this scenario is that, well, one, the buyer didn't get the build contract vetted, which is a big no-no, okay? Just like, you know, real estate contracts. But this particular contract, because it was done early, price locked in, yes, but because it was done very early where the buyer didn't own the land, all of the provisions of the build contract, because they signed it early and they were bound to it with the builder, started to take effect straight away, but they didn't own the land.
Yep.
And that was a major deal for them because the builder a year later, so we fast forward to now, the builder, and they still haven't settled on the land, right? So remember, when you sign it off the plan, you're subject to the developer completing it. So it's out of your control as a buyer, right? So, and remember, this had an 18-month sunset date, and the builder knew this. The builder knew that it could have taken that long to actually have this buyer own the land, and they knew they didn't own it from the beginning. So fast forward a year later, the builder issues a notice to the buyer, right, saying, oh, well, we haven't commenced construction yet. Yes, we know that because you can't commence construction until the buyer owns the land, right? They said, well, because we haven't commenced construction, we're going to start charging you delay damages under clause 16 of the standard HIA build contract.
Oh.
And when they came to me, they said, oh my goodness, look at the costs they're trying to charge me. These are horrendous. What can we do about it? Can we get out of this contract? They're acting unreasonable. Now, of course, I issued letters to the builder and I said all of those things. But ultimately, what I had to say to my client is that, well, there is this clause in the build contract. It's clause 16 in the standard HIA, the Housing Industry Association, templated build contract. It's a standard contract with standard terms, right? And there is a clause there called delay damages, which typically is used where there's a delay in construction or completion. It's got nothing to do with the builder, and the builder has a right to start charging these delay damages, right, to the actual, buyer or homeowner in this case. And it's actually 0.27% of your build price.
Okay.
Right?
So quite a
Per
big
week.
amount of money. Yep.
Per week.
Cool. Yeah.
So they started saying, okay, well, that was a year ago, or say 9 months. So we're just going to start charging you. So every build contract has an anticipated start date, right? So this particular build contract, they signed it in March last year. So they signed the land contract February. They signed the build contract in March. The builder had an anticipated start date of July 2022. But come July 2022, right, the buyer still didn't own the land and the builder did nothing about it. They left their start date as of the 22nd of July, didn't change it, didn't go back to the buyer and say, well, yeah, you don't own the land yet. Let's think about extending this date because you don't own it. No, they didn't do any of that. They just let it sit. So fast forward, like I said, to now, this year, in March, they issued this delay damages, knowing full well that, of course, construction could never have commenced until they owned the land. Of course, they could never do that. So what this buyer should have done is get their build contract vetted in the beginning, and we would have made the contract subject to the settlement of the land. And that's what I've done with many other clients. So the terms of this build contract really can't actually start to take effect until they actually own the land. And that's how it should be with every build contract that you sign where you don't own the land yet.
All right. So you talk about vetting the contract. So that was the problem in this case, wasn't it? So basically they trusted the builder, essentially. Is that how it happened?
Yes, of course. They trusted the builder. And look, the idea of locking in a build price early on sounds very appealing, doesn't it?
Yep.
But of course, that goes by the wayside when the builder has this clause that can charge you delay damages. So in this case, they were adding on an extra 35,000 odd to the build price. And remember, when you're building, every penny counts.
Yeah. Are those delay clauses usually in building contracts?
They're always in build contracts.
Always in build contracts.
Always in build contracts. So you can't really get them out of the build contracts. What you can do in this case is have your contract subject to you becoming the owner. Now, the next part of this story, it was a horror story to start with, but now it's a happy ending because I got the client out of the contract.
Woohoo!
And it was a really good result. And, some people might say, well, why didn't you just renegotiate with this builder? What happened is it was the client's choice. They basically had, a sour taste in their mouth from the builder and said, I don't want to have anything to do with this builder anymore. Yeah. I don't want them building my home. I want to get out. It was made very clear to me, and that's what we did. So
yeah, nice.
Yeah, it was great outcome for them. So how do you do that? So if you find yourself in this situation, you really want to contact me or someone else that understands build contracts, because there was a very clever way to get them out. So I don't want to be too technical, but basically the way we got them out is every build contract has got certain conditions, right? So it says that, okay, within, say, a certain amount of time after that anticipated start date, which was back in July last year for them, all of these things have got to happen. So the buyer's got to become the owner of the land, and there's various other things. One of the things that have got to happen is the builder's got to get all their approvals from council. So you can't actually start construction until you get approvals. That makes sense, doesn't it?
Mm.
Yeah. So that was one of the conditions. Now, if you don't own the land, the builder can't go and apply and get your approvals because you don't own the land yet. So the builder never applied for the approvals, and they would have done so once they settled on the land, right? Because then they can go and lodge the application for this landowner, the buyers, and everything would be hunky-dory. So where the builder doesn't obtain those approvals, right, by the anticipated start date, which is back in July, okay, then, and they still hadn't got it today, naturally, because the buyers weren't the landowners. So they never had the approvals in place, which was great for us because there's a clause in here, 2.5 in your, or 2.2 and 2.5 in your standard HIA that says, well, the buyer can terminate the contract, can end the contract if there are no approvals in place by that start date, which was back in July last year. So that was a great win for them.
Was the builder just being difficult? I mean, they would have. This is obviously not the first time this has happened, and they would have known how it may have played out. Were they just trying to play hardball, just trying to see how it went?
Yeah,
no, absolutely, exactly. So they just issued the notice to my client and said, pay up. And my client was horrified, thinking, well, what's all these extra costs? And this is ongoing on a weekly basis. You're charging me for something I don't even own the land. And I bet you this is happening in a lot of cases out there where people are not even aware of it, and they'll be hit soon with a notice for delay damages in this very scenario I'm talking about, this particular scenario. So you really have to, I think, look at your build contract, look at the terms where you don't own the land, right? I'm talking about where you've signed an off the plan, right? And have a look at the situation to see if you're in this situation yourself, because it was really important. And I think if the builder had taken a different path with my client, it would have had a different outcome, because what they were doing was justifying their increase in their construction costs over the last 12 months. And yes, everybody knows their construction costs have increased and have affected builders. I sympathize with that scenario, but what they should have done is they should have said, well, can we renegotiate the build price? Because this is actually what's happened in 12 months. Here is the evidence. This is what's happened with the price. We can't actually build it for you now, and renegotiate, maybe throw in something else as a result, give them something free, who knows, whatever the deal could have been. And it would have been far better than saying, yeah, well, here's a delayed damages notice, which really should never have been done. So it always, the parties' conducts and how they manage situations always makes a difference.
Yeah, that sour taste. I completely understand that. So good on them for getting out of that one. And just quickly, that was around the Gold Coast, wasn't it?
Well, this was it's to do with Queensland. It's to do with Queensland land. The land was a little bit further up towards Brisbane, but regardless, yes, it's a Queensland property. Yeah,
there you go. Well, thank you so much, Despina. And coming up next, we've been discussing bylaws recently on Talking Law, but this is surprising. Apparently, some of them can be invalid. So if you want to find out more, stay tuned. That's coming up on Talking Law on Radio 97.